An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. Prigg versus Pennsylvania, 1842. Most law students are familiar with Dred Scott versus Sanford, decided in 1857. But few students are familiar with Prigg versus Pennsylvania, decided in 1842. Justice Joseph Story's majority opinion invalidated a state law designed to protect runaway slaves and upheld a federal law that punished runaway slaves. In 1793, Congress enacted the Fugitive Slave Act, which authorized slave catchers to travel across state lines and arrest runaway slaves. This federal law was very unpopular, especially in northern states that opposed slavery. In response, some states, like Pennsylvania, enacted so-called personal liberty laws that prevented a person from being removed from the state without a full judicial proceeding, including a jury trial, to determine whether or not that person was in fact a fugitive slave. These state laws conflicted with the federal act that included only the most minimal procedural protections. Prigg versus Pennsylvania resolved this conflict, finding that the federal law trumps or preempts the state law. At this time, Maryland was a slave state, and Pennsylvania was a free state. In 1832, Margaret Morgan, a slave, left Maryland to marry a free black man in Pennsylvania. She apparently did so with the acquiescence of her owner, John Ashmore. 5 years later, after John Ashmore's death, his widow sent Edward Prigg, a slave catcher, from Maryland to Pennsylvania. He soon captured Morgan and brought her back to Maryland. While the governor of Maryland refused to return Morgan, after a public outcry, he did extradite Prigg to Pennsylvania, where he was tried and convicted of kidnapping Morgan. Prigg appealed his conviction to the Supreme Court. He argued that the Federal Fugitive Slave Act preempted or trumped the state personal liberty law under the Supremacy Clause. The Supremacy Clause reads, quote, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." To resolve this dispute, the Supreme Court had to decide whether the Federal Fugitive Slave Act was constitutional. That is, whether it was made in pursuance of the Constitution. In McCulloch versus Maryland and Gibbons versus Ogden, we learned that Congress can only enact laws pursuant to one of its delegated powers. Study guide. What provision of the Constitution gave Congress the power to enact the Fugitive Slave Act? One possible candidate is the Fugitive Slave Clause, which appears in Article 4, Section 2. It provides, quote, "No person held to service or labor in one state, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due." Study guide. Does the Fugitive Slave Clause grant Congress the power to enact the Fugitive Slave Act? Salmon Chase, who would later become the Chief Justice, argued that the Fugitive Slave Clause did not expressly grant Congress any new powers. Chase argued that unless the text in Article 4 expressly gives Congress a new power, then Congress lacks that power. Compare two provisions of the Constitution that appear next to each other. Article 4, Section 3 expressly says that, quote, "Congress shall have power," unquote, to make rules governing the territories. However, Article 4, Section 2 merely describes the relationship between states and grants no express power of enforcement to Congress. Therefore, Chase concluded, the Fugitive Slave Act was unconstitutional. In Prigg versus Pennsylvania, the Supreme Court rejected the argument that Congress lacked enumerated powers to enact the Fugitive Slave Act. Writing for the majority, Justice Story held that the Fugitive Slave Act was constitutional because the Fugitive Slave Clause was intended to prevent free states from, quote, "intermeddling with or obstructing or abolishing the rights of the owners of slaves." He doubted that the Union could have even been formed if the Fugitive Slave Clause had not been added to the Constitution. But what about Chase's textual argument that Article 4, Section 2 did not grant Congress an enforcement power? Justice Story responded that the Necessary and Proper Clause provides the necessary authority. He wrote, quote, "The end being required, it has been deemed a just and necessary implication that the means to accomplish it are given also, or in other words, that the power flows as a necessary means to accomplish the end." This construction by Story and Prigg extends well beyond Chief Justice Marshall's opinion in McCulloch. It remains one of the most expansive readings of the Necessary and Proper Clause ever adopted by the Supreme Court. On the other hand, Justice Story also maintained that the states cannot be compelled to enforce the Fugitive Slave Act. Rather, it is for the national government to carry into effect its own policies. This limitation on congressional power would provide the foundation for the so-called anti-commandeering doctrine, which denies Congress the power to commandeer or force states to implement federal programs. In sum, because Story found that the Fugitive Slave Act was made in pursuance of the Fugitive Slave Clause and in conjunction with the Necessary and Proper Clause, that act was supreme and preempted the Pennsylvania personal liberty law. Prigg's conviction was therefore reversed. With this sanction given by the Supreme Court, Congress could go on to pass an even more draconian Fugitive Slave Act in 1850. Study Guide. We have come to associate the southern side of the Civil War with that of states' rights. Does the assertion by Congress of the power to enact the Fugitive Slave Act and the outcome of this case cloud that picture?